forum. Want me to repeat that?
Sure.
Based on, a call the meeting to order and based on the people here, we do have a quorum. So first up after that would be approval of the minutes, September 23, 2024.
And for the voting member.
Yes, okay. And you're a voting member tonight. Thank you for that.
I move the board approve the minutes of September 23rd as written.
Second.
Any discussion, anybody? Then all in favor say aye. Any opposed say nay. Right, old business is development review ordinance, David and Joan Lopsy, map 31, lot 5E, application MD 01-24 to subdivide the lot into 4 parcels. We were gonna have a lawyer present for this via,
Via Zoom. She's not here.
then I move that we take the agenda out of order and move on to land use ordinance for now.
Second.
Any discussion? All in favor, say aye. All opposed, say nay. That brings us to land use, Bill Pilden, map 24, lot 24, application LU 46-24 to construct a log cabin on site of former trailer using existing power, water, and septic. We had a site review. And says the only question is the septic capacity. Did we get anything from,
We did not. He's been having a hard time getting Will up there to actually look at it. Everything else is good. Setbacks are all
right?
good and everything else. What I would recommend is approval with a contingency that before any residence is occupied, the septic is certified as sufficient.
Okay, and if it's not,
If it's not, then he cannot occupy the home.
and how do we enforce that?
He'll have to come see me
Yeah, that's the problem.
after it's built.
You have to do a plumbing inspection on
Yep.
a new house anyway.
Yep.
Okay. If that's acceptable to the board, is there any other questions that we have to deal with?
He has a 1,000-gallon tank and
There is a 1,000-gallon tank.
they found the 4 corners of the
Yep.
field.
And there was originally a 3-bedroom residence on it.
It was, no, it was a 2-bedroom.
Oh, 2-bedroom, I'm sorry.
Two-bedroom trailer.
Okay. It's, so all we did last time was table for septic and for site review.
Yep.
So next up is what is it complete?
We move that it's complete.
Why?
You didn't get the other question answered, so you gotta get that letter.
Dave just gave us a way to do something
Right.
else.
Okay.
Yeah, with a condition that, yeah. I would say. Okay.
So move it's complete with the condition. So I'll move that application 46-24 is complete contingent on receiving septic analysis report.
Second,
Second.
discussion? All in favor, say aye.
Aye.
Any opposed, say nay. Approval? There's nothing to do with the, public hearing.
Do we have-
You can,
I move a public hearing is not necessary for application 46-24.
Second.
any discussion? All in favor, say aye.
Aye.
Any opposed, say nay.
Nay.
Somebody say nay?
Is the package complete?
We're talking about, we just determined that it was complete, yes,
No,
and we're
no,
talking
that's what
about,
she said. I couldn't hear her.
you came in a little late, we were talking about,
I couldn't hear Isabel. Can you repeat what the topic was that she said was? I can't hear her.
okay. First of all, we're on land use ordinance with Bill Tilden's application. We're not on the Wiltie application. And secondly, could you say it again, what she said? Or
Public
can she
hearing.
say it again, what she said?
Public hearing is not necessary for this application. That's what they're voting on.
What she originally said, it was that the application was complete contingent on getting an,
Certified
a
copy
certified
of the
thing of the
septic
septic
report.
system.
So it's not complete.
Yeah, it's complete with the exception of that, and we're going forward with it, and
Right, it's
Okay.
either complete or not complete.
You can't question us, Karen.
Yeah, forget it. It's past-
We
it's
have to.
certified.
You're
No.
not looking out for butters. You are not.
There is no butters on this.
I understand. I
okay,
understand.
moving forward,
Wait, we didn't, did we get a vote on that? I'm sorry. Did,
on which,
on the, public hearing not
I
necessary?
don't think so. Did we get seconded? Gil
Yeah,
seconded.
we
Yeah, the second is, there was yeas. and then
Okay.
there was the
We
one.
went to discussion and,
Okay,
we were voting actually,
Yeah,
yes.
and so I heard somebody say nay, and I was looking up to see who said nay.
So we had 5
So
yes
good.
on that, right? Thank you.
I move the board approve application 46-24 contingent on adequate septic before occupancy.
second.
Discussion. All in favor, say aye. Any opposed, say nay. Good.
Hey, Bill, sorry, point of order, are Ann and I both voting today? Or just-
Ann is right now. Your input is still welcome. That was approval, yes.
Yeah.
Yes.
So there's a one signature thing, permit that I've got to take care of at a certain time this week. I still don't see a lawyer.
Was she coming at 5:30?
I'm not sure what
No,
time
She
it's
was
set
supposed
up.
to come in at 5, and she said she had another meeting to jump to at 6. We discussed an hour being plenty of time.
Okay, continuing on out of order, Paige Clayson, map 25, lot 14A, application LU 47-24. Change of use, storage and office to residential with related renovations to existing buildings. Again, we had a site review. While on that site review, one of the questions that was asked was the well and septic system from the neighboring lot, was that looked at?
Yes, yes, everything's good.
Everything's good?
Yep,
Yeah,
Okay,
all setbacks and that, everything's far enough away from me, everything to,
yeah.
nothing's gonna be an issue.
and I recall you were gonna check with the plumbing codes or something about the closeness of the slope of the,
Yeah, but they have plenty of room, because when we checked it, the measurements that were on the piece of paper were off a little.
okay. That's where all setbacks are met.
Yep.
I think a separate concern was that our setback requirements were not up to date with the state code.
Yes, that's right, that's correct. And I couldn't find in the green book where you found that,
But the five.
yeah,
Oh,
so maybe you had a
different
different version.
Really?
Yeah, cause what,
So
what,
that was
when
five?
I looked in
Yeah,
my copy in the office, it matched.
it's
Same.
fine.
Yeah,
So we need some
you need,
updated.
yeah, I think you need
pages.
an update,
And that was, what was it, the setback from the
5 feet.
5 feet?
Yeah.
And I had 10?
Yeah.
15.
No, yeah,
Yeah, for the berm, for the berm.
All right then.
Yeah.
I'm not sure.
There's no question, we need to have these personal books updated,
Mhm,
the
mhm.
personal books.
Yeah,
Okay. Back to LU 47-24. Is it complete?
I move application 47-24 is complete.
Second,
Discussion. All in favor, say aye.
Aye.
Any opposed, say nay. Is there a,
I move, public hearing is not necessary for application 47-24.
seconded? Any discussion? All in favor, say aye.
aye.
Any opposed, say nay.
I move, the board approve application 47-24.
second,
Discussion. All in favor, say aye.
Aye.
Any opposed, say nay. I have, and this one it's only still a one signature.
Yep.
All right. I move that we return to the agenda as written.
Second,
Discussion. All in favor, say aye. Any opposed, say nay.
you're done, Paige.
So I don't need to be here?
you're
You're welcome to say.
yeah.
Well, I might find something else to do. I'm assuming that I passed all right and good to go. Awesome, thank you. That is a record for me.
good timing.
All right, I am a little bit at a loss. We don't have our lawyer present. Is there anything that we can do with this without them on board right now, or?
The lawyer did provide some written responses, I think. I thought-
No, that's an older one
Oh, okay.
that I printed out just for
Can we
reference.
just find it the facts or no?
That's up to the board.
They would be subject to change, I feel.
Would they?
Just a question.
I mean, I think that would be, if they were subject to change, they would have to go through it again, right?
Yeah,
Just-
and we'll
just the
do go
one.
through it again and.
Yeah, because we go through the written.
Well, maybe we can just discuss, what she provided, the attorney provided us in July 24th. And see if that answers some of our questions. Because you may have repeated questions that already been.
Oh, I have no doubt we've repeated questions.
Yeah, just to go through what she provided.
Might I have a copy of it provided by the council?
I'm
I
sorry,
have a copy of the letter of the July 24th or whatever it was that you're looking at. I understand.
oh, you haven't?
No, sir. Thank you.
One item I noticed under what are the frontage and road requirements, if she has the shoreline frontage should be 200 feet, not 150 feet. And all the lots on the shore have the 200 feet.
And that's on that.
Mhm. And so she then says, frontage requirements are met for lots 2 and 3 on Trim Lane.
As far as what frontage?
Trim Lane,
Road frontage.
road frontage, correct, thank you. Yeah, and that, lot 4 does not have adequate frontage. And so that the right of way should be extended down as shown probably on the plan, 150 feet. Into lot 4 to provide sufficient frontage onto Trim Lane.
Okay, is that a requirement or is that a suggestion?
It's a requirement for frontage, all
For,
lots,
for frontage, but then we have landlocked,
other.
landlocked lots in the other places on the island, they don't have any frontage. And he didn't originally,
According to subdivision regs, they should have frontage on the access road. We can look it up. I don't know if I can zoom it to figure out which one it is, but that could be a question we can look into, but I'm pretty sure that our subdivision regulations require frontage on the interior road.
okay,
And that, she does agree that a 50-foot right of way is required. And that traveled road within the right of way must be sufficient for emergency purposes, so she's talking about the access roads for subdivision, for the subdivision.
right,
Which is Trim
which
Lane.
is the road we walked up during our site review, which, who went with that? That was Isabel and myself and Dave. And what did we call them, but not bystanders, what did we? Tag along.
Yeah, that's good.
And my observation was that you could get a fire truck up in there, in my observation, but I don't drive a fire truck. Have you been up through there, Mert?
I can't hear.
Oh, I'm sorry. We're talking about the access of fire equipment up to Trim Lane, and if you wanna look at this map right here, it would be to a certain point.
Yeah, I'd have to look at it another time. I haven't seen anything.
Yeah.
Yeah.
Yeah, I was thinking actually that in terms of, we're gonna require a cul-de-sac that, Merck be involved in, or the planning and setting aside area for a cul-de-sac.
I apologize. I'm a good hearing aid in the shop and I'm working with a clunker.
You come closer,
And I can't really hear it all.
come closer.
up.
So I don't think it'll matter up there.
That's all right. The cul-de-sac that you're talking about, whether it's a cul-de-sac, whether it's a hammerhead,
Needs to, I would say, approved by Mert, the location.
we've also got guidelines in our,
Yeah, yeah, yeah.
for dimensions, not so much location, I
Right,
guess.
Well, she had suggested having it down at the end of lot, the right of way on lot 4.
Right?
I thought that was kind of far away, particularly.
And my thought was right here at the curve where it goes into the Dexter property and lot 3 and 2 combined, where it goes into that curves.
Yeah, I agree.
I have a question for Mark.
We gotta be, you
Excuse
gotta,
me,
You can ask him afterwards,
after the
right,
meeting.
Well,
she's
it's on
gotta
this
be
topic,
recognized
though.
by you.
then,
Not come out of
then,
order.
then walk outside and ask him the question, please.
Well, I'd like to ask it on this topic.
Yeah.
of
You
the
can
road.
ask him on this topic, or go outside, Tara.
It's relevant to this meeting.
Not right now, it isn't.
It is. It has to do with the inaccessibility in the winter of all of the steep part and down
Karen,
and not
Kara,
taking care of
Kara,
road.
Kara, stop.
Our
I'm
road's
gonna-
not plowed and it's,
All right.
I count on not
Just
getting
gonna-
there.
I move to table this LU MD 01, so that lawyer is present and able to take care of any questions that the board might have.
and that we request that audience members do not participate in the planning board discussion.
Can I not ask Mert, who is a member
Go
here?
outside.
He
He's a
just told you.
professional here for this topic. I
The
can't
vote
ask
has
him a
been put to a
question.
motion.
I second it.
Why not?
Any discussion?
It's our meeting.
Any
I
discussion?
know, that's why I'm here. Because no one's looking out for the abutters' rights and the Sunset Acres owners'
The vote
rights.
has been put to a motion, has been seconded, looking for discussion.
Well,
I'd like discussion.
Yes. Yeah,
So I think we don't understand, I think maybe the community doesn't understand the rules of how the board operates. And so maybe if we
It
elaborate
doesn't matter,
that.
she's just butting in anyway.
Hang on.
Well, I think we can give the benefit of the doubt. So, Kara, I believe the conflict is coming here because there's a point where the board discusses items and requests testimony and requests evidence. That isn't the time for members of the public to weigh in with additional questions. It's only for the board. Then there is a point in time when we're evaluating something and it's been put to a vote for, and discussion is specifically opened on a topic, that audience participation or community participation can be invited.
When is that?
not during
No, that's
our
not true.
discussion.
No, not during our discussion.
No.
When is public discussion permitted?
Later on, in other business where it says people wishing to address the planning. board.
People wishing to address the planning board. Okay, thank you for clearing that up.
When can we address specialists who have come to this topic on the same types of issues that have been brought up by abutters? And we now have a specialist.
During that time,
Which time though? When is it?
at the end of the meeting for people wishing to address the planning board.
I honestly feel
But
that
they will not address the lawyers. Only people that can talk to the lawyers is the board,
Okay, so they cannot address,
the
Yeah,
lawyer.
yeah, specialists
They
would
will
have to
not
be-
talk to.
addressed independently, not as part of planning board business.
Yeah, she'll have to do it outside this office or something, but the letter we got from the lawyer said that she will
I'm
not talk
ready
to
to
any of the
delay
public.
anyways, because we don't have a lawyer present.
And, maybe we can have some more information from Mert when he can.
Fine.
And maybe we could have executive session before.
No, we're not going to executive session right now. The vote is made, the motion is made, it is seconded. We have maybe discussed it. Is there any further discussion?
I
All in
guess
favor, say
I
aye.
apologize to
Aye.
Mr. Rose.
Any opposed, say nay. So when we can get something in writing from the lawyer or something visually, which you can, then save it.
Jennifer, I can hear
Do you
you.
want to review this?
I don't think it's true. I think you need to look at your mission, which isn't just for someone paying money to develop, but existing people in a
Have
subdivision.
you reviewed the ordinance?
We're still here. Yes, I have. Subdivision owners have a lot of rights that aren't being honored here all over the place. All over the place. That's why previous Northeast subdivision met with the whole town being outraged. It's,
Okay, we've moved on
No
from
due
this. I'm
process.
sorry, but we've moved on from this. Right now, we're at CEO report and we have none. I'm sorry if all of you people wasted your time, but we did not get everything we were looking for. CEO report, none.
Don't have one.
Okay, people wishing to address the planning board. Todd,
I would like to address the planning board. I'm Todd Congdon from the Ugly Butter. This subdivision plan that I see right here is not the subdivision plan that was described to the abutters. Let me read to you the last paragraph of the letter to the abutters. I'll put my glasses on. We recognize that some of you dispute our right to provide access to the land south of the Chase land, the land that we acquired from Carol Corby. Although I hope we can someday amicably resolve that dispute, the former Corby land is not involved in this subdivision plan, so access to that land is not an issue.
and that's the lot 4 that we're seeing, I
Yes.
think, correct?
Mostly.
All right, well, how about if we present that to the attorney? We didn't have that copy of that letter
You
in
did?
front of us. We did, but we missed the fact that, as you had pointed out, that there was a change that we required lot 4.
There are a lot of abutters that I would imagine have no idea that that lot is part of this subdivision. Now there were more.
Yeah.
The lot 4, it means 1, 2, 3 more. Makes a big difference to some of those people like that.
They all got letters in the very beginning.
This letter that said it's not part
The
of,
abutters got letters.
you know.
Not all the members of Sunset Acres have received letters or notification of any of the sequence of events starting in 1985. We have not been informed, things have not been legally changed. There's deeds that were said, people own things and they gave it away. There's lawyers who have very different opinions on the same topic, depending upon who the landowner and who they're representing. It's mess
We're not
upon
talking
mess that you are
1985,
allowed to go
2024.
forward with continued mess upon mess. There's no paper trail of Sunset Acres as it exists today, which is very different from this. 3 of these survey borders are in dispute. The pie slice next to Mr. Blackburn, the
Blackford.
Mr. Blackford, the paper road between my land and the Losies that is not owned by the Losies. There's no proof of this. No one has shown me a deed. All the roads
It's not
are
owned by
owned.
you either. It's a paper road.
Okay,
It's a
okay.
paper road. We own 25% to the center line is what I'm told by surveyors and state of Maine law. Then we have this part back here that the abutters don't agree with. So 3 different boundaries of this, which is a new map to all of us tonight,
No,
are in dispute. It's not the one we started working
it
with.
probably, I guarantee it's not the one we started with.
It has a different name. Did anybody read the first paragraph, which does not, the surveyor saying none of this can be backed up? I mean, did you read that first paragraph? Because it disallows this whole
I don't know.
plan. I recommend you read it.
I know.
We have the lawyer.
I know. I'm aware. Thank you. She just told me that one of the questions that we have to the lawyer is addressing that very statement that you just made.
Can you read it, please? So that I know what's gonna be looked after.
A survey plan provided by the applicant shows the east property line of proposed lot 1 extending along the western property line of Seekman. Seekman claims she should own to the center line of the paper road Trim Lane, which paralleled her western boundary. How should the planning board handle this issue? Can we approve the plan with this issue and rely on the surveyor's review that the correct line is as shown? So we're waiting
Thank you.
to get an answer.
Good.
Thank you.
Can I go to Todd?
Sure.
Thanks. Todd?
Just very quickly, a lot of the meetings that were tabled because of different reasons, but the last real meeting that was discussed, lot 4 was not on that plan. The first time that plan, that showed up was when we had the site review.
No, it was before that. You had to have that to go on the site review.
You had, yes, but it wasn't this plan. This was a new plan.
Originally, it came to us as a, subdivision of 3 lots.
Right, and so,
Original.
yeah, lot 4 was there, but it was not labeled lot 4, it was
It
kept by.
was, land,
Yeah.
owned by the Losies and.
Right, and that would
Other
agree
hands.
with the original, letter to the abutter, but then it changed at
Mhm.
that point, yeah.
And at that meeting that you're discussing, is you're talking about now referencing, if we asked Mr. Losi to provide an updated map that showed lot
Uh-huh.
4.
Uh-huh,
So that's why we have that map.
yeah, and.
Because the determination was made that it was not a 3-lot subdivision, it was actually a 4-lot subdivision.
Mhm.
Because it was originally 1 lot, well, at this point, it was 1 lot being pied out sectioned off into
Right.
4 lots.
But then it just begs the question that was, referred to in the letter to the abutter, that where the Losi's say that they recognize the right to that right, that lot is disputed. So it's, it sort of makes that a sorer point.
Yeah. Go ahead.
Oh,
There's the
oh,
lawyer.
there's the lawyer.
Okay. But we've already tabled this.
Have you?
Well, we can
Sorry.
start the discussion.
You're way back.
Hi, thanks for joining. I'm so sorry. For whatever reason, this was on my calendar for tomorrow.
Okay, well, as it stands right now, we've tabled it till we had you on site. And I was thinking that would be in a future meeting, but now that you're here, can we reopen it? As we haven't left the session yet?
Yeah.
Has anyone left who's important to this?
No.
No, not yet, I don't think.
There you go. Untable it by motion, I suppose.
Yeah, I would think it would take a motion. All right, then I'll make the motion that we take it off the table, excuse me, MD 101-24. Now that the lawyer has joined us and readdress some questions that we have.
Second,
Discussion? All in favor, say aye.
Aye.
Any opposed, say nay. Okay. Who wants to lead off with this?
You got it right in front of her.
Do you have a copy of the questions that we have sent?
I do, and I had draft responses that if everything had gone as planned, you would have had in hand before the meeting. So, if you reference one of the questions, I can refer to my written out answers and hopefully remind myself of what I was thinking.
On our sheet, September 6th, 2024, first question says, can a subdivision occur within an existing, subdivision, AKA the Sunset Acres of 1968? And then it says, secondary part of that question is, what, if any, restrictions of the older subdivision apply to the current subdivision?
Right. So yes, there can be a re-subdivision of a subdivision. So if any lot created in that subdivision were then divided again twice, that would create a new subdivision. The conditions that were applicable to the prior subdivision may or may not need to be applied to the new subdivision. It kind of depends on what the ordinance says and what the lay of the land is as of the date of the application. So I think the planning board just needs to look at whether circumstances have changed, whether the original conditions, still make sense to apply to this new subdivision.
Okay, anybody need further explanation?
would these new lots still be considered Sunset Acre lots?
No. I wouldn't think
So-
so.
Yeah, I mean, one thing that I touched on in my written response was if there were private covenants that attached to the parent lot, then those covenants still should attach to any divisions, any new lots created within that lot. And so I tend to think that for the purposes of private covenants or any restrictions within the subdivision, those still apply. So for that purpose, it is Sunset Acres. But in terms of how the town looks at it, it is a different subdivision.
I think I'm thinking of, access on the private road. Access from Marshall Cove Road, whether they would still have access or not.
So on the very basic, real estate law that it would apply to that, if a parent lot has access from a right of way, that lot can be divided and the resulting lots would still have rights of access. There's a point, and this point can be a little bit nebulous, that perhaps if you're dividing loads and loads of lots out of an original parent lot, that it overburdens the easement, and that might be a private issue between the property that's burdened by the easement, the property that's benefited by the easement. But generally speaking, yeah, those lots would still have access over the subdivision roads, Sunset Acres roads.
But, if it became a burden, that would be a private issue.
Exactly.
Okay, thank you.
And, if there were let's say I don't think this is the case here, but let's say there were restrictions within the original covenants against further divisions or further burdening of the roads. That is something the planning board could look at, because that is a practical impediment to access. But, I don't think that's the case here.
All right, one of the next questions. Going with paragraph 2 here, Sunset Acres originally showed trim lane paralleling western boundary of the Seekman lot. In January 85, the Islesboro Planning Board approved the change in a location of trim lane to the current location, making the paper road trim lane obsolete. The surveyed plan provided by the applicant shows the east property line of the proposed lot 1 extending along the western property line of Seekman. Seekman claims she would own to the center line of the paper road on trim lane, which parallels her western boundary. How should the planning board handle this issue? Can we approve the plan with this issue and rely on a surveyor's review that the correct line is shown?
Yeah, so I disagree that the westerly line of Seekman would be relocated by the fact that the planning board relocated trim lane. I think the location of that boundary is dependent on where the boundary was intended and where it was physically located at the time of the transfer, the time of that deed. But beyond that, again, private issue as between the two landowners as to what their respective boundaries are. But I think that the planning board is free to rely on the deed and free to rely on how a surveyor presents the issue if you think that information is all relevant and doesn't show on its face, at least, that this applicant doesn't have the property in question.
The applicant has provided deeds showing that he owns a right of way on lot 1, which has access to adjacent Martha Cove Road, private, to the public Meadow Pond Road. Subdivision, is it sufficient to approve a subdivision when there are potential right of way issues with proposed lots? And the B question on this is, if this can occur and not result in the town being sued, what condition disclaimers should we have in place on the deed?
Yeah, and maybe I'll start with that one first. So obviously we can't guarantee that any of the interested abutters won't appeal your decision, regardless of what the findings are. And I think when you get to these title questions or rights of use questions. This is the decision the planning board is going to make is going to be defensible as long as you have evidence of right title and interest in front of you. And the fact that there might be a dispute, there might be this private issue, the case law says still that the planning board need not resolve that. And all that matters for you is, do you have a document in hand that purports to give these rights? And that seems to be the case here. At least with the, I think there's some question about whether Lot 4, the retained land, ever had access. That question is a little trickier, so that's kind of jumps to sub-question F there. But in terms of the rest of the development that the deed describes access by the right-of-way, that to me satisfies your what's called the prima facie test, on its face to show that there's a claim of right title and interest. And again, that's all you need. A lot of times I'll have boards, and you could do that here. You're going to kind of need to do that here all over the place, is to say, private rights were alleged that said the boundary was here, or said that the right of way didn't include access to these lots. However, the board cannot and does not by this decision resolve those issues. And that is enough cover for me that you're not purporting to, do something you don't have jurisdiction to do, which is resolve title disputes between private landowners.
Is everybody clear on that?
Mhm.
You're basically saying that right-of-way issues are a private issue between landowners?
Yeah, when it comes to the scope of a right of way, I think I look for language in a deed. And if there's language in a deed that benefited this parcel with the right of way, and particularly if it's bolstered by a survey or a surveyor's opinion, in my mind, that is enough. Now, again, I think this question over the Lot 4, the retained land, might be a little bit trickier since it said that it's only for the former lots of the subdivision. And that, if we're clear that the lot or the land that it's describing as the land formerly owned by Corby is or includes Lot 4, that one's a bit more nebulous.
I'm gonna play the dumb card. What does nebulous mean?
Oh, sorry. It's not clear to me that the applicant has shown right title and interest to access to Lot 4, to the retained land. Because from my understanding, and I'm sort of coming in from the outside here, but there seems to be quite a lot of dispute, and maybe rightfully so, that the retained land on its own, when you cut off the rest of this, has access over that right of way.
She has an old map.
Mm-hmm.
She's saying retained
Yeah.
land.
She's not working from this.
I'm using them as one and the same. I mean, so Lot 4, as far as I understand, is being retained by the current owner, right?
That is our understanding as well.
It's shown as Lot 4 now on the subdivision plan, but yeah, it's being held back by the subdivider.
And there was a comment made from your office, I believe it was from your office, about possibly making Lot 4 have 150-foot easement or right of way.
Don't remember saying that.
It's regarding the frontage on the subdivision road, that lot doesn't show the the frontage.
I think that the lot that is being held back, we can't create a lot through a subdivision that doesn't meet town standards. So I do think it has to show frontage. It has to show frontage on a, an appropriate right of way. And then if they can't demonstrate that they do have that frontage, whether because they don't have enough feet or because they can't substantiate that it's a valid right of way, then that would be a problem with that fourth lot.
So that would be considered a condition that if this lot 4 is ever to be sold, that it has to, show, access to Marshall Cove Road or somehow to the town public road.
Or to even be created.
Yeah, it may be that it's even to be created is the question. So I would wonder what the owner's intention is with this lot. Is there any other means of access to it off of the far end of the lot as opposed to through this right of way? Is there another way to skin that cat to give that lot access? I don't think that even if it's not one of the new lots to be created, because of the subdivision, it is, by sort of omission, it's leaving this lot behind. And so that's creating a new lot. And so that lot has to meet all the ordinances, lot standards as well. And then it would include frontage. So I think we're maybe a bit far off on lot 4 is what I would say, in the sense that I don't know that you've received a lot of information that could be relied upon that says that lot 4 specifically has title and interest to get over that subdivision road. And you don't have, for instance, a lawyer's title opinion asserting that, do you?
No.
I don't believe so.
What that might mean, practically speaking, is that the only option, if it appears from everything you're seeing, and it seems to appear that way from everything I'm seeing, that lot 4 doesn't have deeded access, then the subdivider's only option here, I think, would be to keep that lot merged with one of the others that we know does have access. Or to get a, pretty definitive opinion that tells us we're all wrong in questioning this, and there is certainly access.
Another question that has come up, and I will ask it. Lot 4, which is the one we're talking about right now. The question has come up as to whether the abutters on the other side of lot 4 have been notified about this subdivision. Is that something that, we need to get addressed? Because that section over there, that would be Carl, I can't read it.
Carl Stemple. Oh, it's Carl Stemple.
And is the whole thing possibly?
Yeah.
Do you know, Mr. Lucy, if that, and that one, Osborough Island Trust, I believe they've been notified, I think.
Well, I certainly talked to Osborough Island Trust and to Carl Sheffel. Carl and I walked that whole thing. Whether he has a letter and a green card or not, I don't know, because remember, I wasn't including this when we started the whole process.
Right, I remember.
But he and I certainly have walked that area and he understands what's going on, but if you need more than my representation, I can get something from Carl.
You asking us a question?
I'm asking you the question.
Ask the question.
The original, the abutter letter said that wasn't gonna be a part of the subdivision, of somebody who would be largely affected by that, miscommunication is the Camp Conundrum owners, where they have a big line along the lot 4.
They got a letter.
But they got a letter that said, we recognize that people dispute and that it's not gonna be a part of the subdivision. That's what the butter letter said.
Okay. That's enough,
That's all right.
yep. I understand what you're saying.
Okay, that this is, so they wouldn't have to consider this being part of.
I
the
understand what you're
subdivision.
saying. They're aware of lot 1, 2, 3, not lot 4.
Right, right.
I understand what you're saying. Kara,
This map, this new one also does not give the Congdons their previous frontage and access. It gives all of that right of way to Camp Conundrum, but not to the Congdons. The line is redrawn. So their frontage is changed on this map.
Well, that's-
It takes my back road and it only gives right of way to Camp Conundrum. And now the Congdons on this map do not have right of way. And also we've been told that the right of way, which has changed from the land that should be 50-50, is going to be written on deeds later. I don't believe that because the later things haven't happened up Marshall Cove Way.
okay,
I
going
thought,
back to,
I thought the Congress paid or bought property for access. Don't we have
It
a letter
wasn't
somewhere?
theirs to buy and it wasn't the sellers to sell. It's all a
all right,
mess
that
upon
sounds
mess.
like something that is involved with property disputes and personal disputes.
Right of way to
Right.
a town
So-
member.
Do we have any
Changing
further
of
questions
subdivision.
for the lawyer?
Well, should we, request that of applicant send out the, abutters notice to everyone with a proper map? I mean, showing that this additional area, though we're still in question of whether it's going to be merged with another lot or if it's going to be its own lot.
I'm looking at the ordinance right now in terms of where the notice provision is.
In the front somewhere.
The land use.
Yeah,
The notice.
I think the notice is really gonna depend upon what the end structure of the subdivision is gonna look like. Like, if we can't get the access resolved to lot 4 and it has to be subsumed into lot 3, then that should be the notice. If lot 4 can be demonstrated to have adequate right of way,
Yeah,
then
so-
that should be noticed.
That needs to be put on hold.
So I think the question that maybe that we can present to the applicant is that lot 4 needs to demonstrate right of way, in accordance with, the town ordinances.
And is that just a paper road? Is that what we're talking about to be built later if need be, or?
Yeah, right of way doesn't require an actual road construction, it just needs to have demonstrated right of way.
Exactly.
You got it's there.
On the notice issue, I just found it. It does say that the applicant certifies to the board that notice of the time, date, and place of the public hearing has been sent by certified mail to all abutters as defined in this chapter of the property involved. So I would say the property involved would be the entire original parcel here, which includes lot 4 as well. So I do think that needs to happen. And if the board's going to table this to request this additional information from the applicant, that's a good time to also send out that notice. Now, has the board already held a public hearing, quote unquote, on this?
Yeah,
Yes, doesn't mean you can't hold a second one, but it doesn't, but we have held one.
Okay, and I would suggest that once, you know, there should be a new public hearing scheduled. You probably aren't in a position to schedule it yet because it's going to take some time for the applicant to get you this material. So once you have feedback on when that's coming in, I would schedule the public hearing. Then the applicant should send out that notice. And then at that meeting, you're going to open up a new public hearing to allow anybody who wants to speak. You know, and I think I'd open it up to everybody, not just anybody new who's been notified.
Right, because it'd be basically a brand new, public hearing.
It would.
Okay. Do we have any other outstanding questions that were?
Number 5, the owner of Marshall Cove Road has stated that the current lots off Trim Lane have easements for use of Marshall Cove Road to access Trim Lane. How can Mr. Losi grant rights of way to other parcels on Trim Lane from Marshall Cove Road if he doesn't own Marshall Cove Road?
I think this was explained with the right of way in terms of subdividing that the child lot inherits from the parent lot.
Oh, okay.
Unless the person providing the easement can demonstrate that it's an undue burden on the
So
easement.
it's the same.
It's
Trim
still,
Lane
it's a
and-
matter of private dispute, the usage that Marshall Cove Road incurs.
Exactly.
There's question number 8. Do we need to be concerned at all with, utilities? Phone poles do exist based on the subdivision plan.
Yeah, phone poles exist. Any other utilities to be considered would be private rights, so those are going to go on the individual lots.
Okay.
So I mean, I think the utility easement question is hand in hand with the road easement question. But if the lot is already served by poles, that kind of demonstrates that there was no question about whether there was utilities within the contemplated easement.
One of the other questions about the roadway, whether it's a right of way or Trim Lane or even the private road, Marshall Cove Road, there was talk about and never formed like a road committee or a road association, is that, yeah, road association. And I'm looking at this. And it says to comply with town ordinance for road frontage, Trim Lane Road, and that's something else, and that's a lot for. The planning board should be concerned about, and is this something the planning board should be concerned about, road association? And the following with that is, should a construction guarantee for the road be a condition of approval for future, stuff? How would that work out? And I honestly don't know how we could even do anything with that, because it's a private road, and how do we go ahead and mandate that there be some sort of a fee if you tear up the road during a certain period, like we have on Islesboro right now? What is it called? It's a escrow?
A road escrow,
a
yeah.
road escrow,
Yeah, it's a different.
Yeah.
thing.
but it's a
That's-
whole
that's
different
for-
thing
that's
with
for
a private
account there.
road.
For road guarantee,
It does.
being part of the subdivision, I believe, the applicant is responsible for upgrading the road to meet the town criteria, the subdivision ordinance with criteria. And that they have to, prior to the sale of a lot, have the road upgraded to meet town criteria before the sale of the lot, according to our ordinance.
Exactly. And so if it doesn't say specifically that it has to be constructed prior to sale, that would surprise me, and I can check on that. But usually what I would see is that the applicant has the burden of bringing the road in up to the standard, and that they have to give a performance bond or another guarantee that they're going to do so. Because what you don't want is for them to sell lots in reliance on this road, and then the road never gets built out properly. And then the buyers are left holding the bag on that, or worst case, somehow they expect the town to do something.
That is our current situation in Sunset Acres subdivision at this moment. That exact situation happened. The subdivision happened, but not the roads. So this subdivision within the subdivision.
Yeah, actually,
is based on
just in
inadequate
terms of
roads.
reference for that, the sale of the lot, it's under section 45-81 is where I found it.
Could I just ask a question? If everyone can hear me. So the lawyer, the attorney is saying that,
Who's speaking?
That's Robin.
Okay.
yeah, the planning board would require, the subdivision owner to upgrade a private road to a town ordinance requirements. Is that what you're saying?
Within the subdivision.
Within a subdivision.
So you're mandating town bylaws on a private road when there's nothing written in the planning board notes or bylaws that regarding private roads and how they're treated in a subdivision.
No, the ordinance has specific standards that do apply to private rights of way. So they have less stringent standards that apply to the private rights of way in terms of width and depth and materials and all of that stuff. But it is definitely in there and also requires a subdivision to comply with those standards.
And the town would make sure, would be checking that this private road is up to the town standards.
Correct.
Yes.
Now, in terms of road associations, is it correct to say that we can require a road association for the subdivision lots for insurance that the road is maintained to the standards, town standards?
Only if the ordinance specifically requires that.
But you can say that the owner of the road must do that. To
You
those
can say
standards.
that the owner of the road has to build it to the standard, but you can't require any certain mechanism for making sure that it's maintained going forward. And the fact is, this used to be more complicated than it is now because homeowners didn't have a lot of leverage to try to join together to get maintenance taken care of. The statutes are a lot better about that now. So if I'm an owner on a private way, a subdivision road, or even just, it's not a subdivision, but loads of people are benefited by it. I can either, along with some neighbors, petition to have a road association formed, which the statute sort of requires to be formed if it's initiated in the right way. Or there's a newer statute that says, I get to do the work and I get to bill all of my neighbors their pro rata share. So, even if we don't have something written in here because we don't have authority to do it, at least the people buying this subdivision would have some mechanisms available to them.
So we could just recommend a road association, but not
Mandate.
require.
Yes.
I believe we have any further, because I do believe that, I know she came in late to us, but she also has another meeting to go to.
My fault on both sides and my apologies, but it sounds like for what we have right now, I think that you're in a good place. And I think at whatever next hearing this information is brought to you, if you can get it to me in advance, and I'll be there for the entirety of that meeting, having reviewed it in advance. And I think we need to work through each of these lots in terms of what rights have been established and, do they satisfy the frontage and all of that, and do it in a sort of pragmatic way. Maybe not official findings, but just sort of walking through to see where any deficiencies are. The next meeting would be next month, right?
No. The next meeting will be
October 21st.
Oh, this was special.
Give more time. But we do every 2 weeks.
Right.
I think it's a question to the applicant about how long he thinks he needs.
I'll try and answer that if I understand what it is that I'm to do. If you want a further I mean, I saw this letter, from Attorney Collins, dated the 24th of July, just a few minutes ago. I don't really have any problems with it, reading it through quickly. I kind of agree with most of what you said. But there are other things, like, for example, the history of the line where the road was originally drafted, or originally set to be, and what transpired step by step. Went through the initial hearing, but I'm happy to go through it again and give it to you in writing so you can forward it on to Attorney Collins. Some of the Lot 4 issues, I don't think this board is in a position to make determinations of title. I think that by statute, only the Superior Court can make decisions with regard to title. And I suspect Attorney Collins would agree with me on that, but I could at least, if it's useful to you, explain why we believe that access does exist. Certainly a prima facie access or sufficient access. That as we have discussed, Attorney Collins, right title and interest.
So
Exactly.
I think we can get over that hurdle. Point is that I can put all that in a letter pretty quickly that you can get to Freddie Flaherty if you would like.
I think that's what we need is your standard, argument about right title and interest and why your deed shows that you've met that test. And if you have any other backup information for that, throw it in there as well. And then, of course, that also means that anyone who disagrees can put in their information too.
So specifically, I think, what we're looking for is demonstration that Lot 4 has right-of-way access to it. And so that it can't be evaluated separately from the other 3 lots, that altogether, each of the individual lots need to have right-of-way access and are considered as a subdivision as well.
Well, there's no question about any of these except 4, right?
Exactly.
All right. Originally, if you remember when I came here, it was a 3-lot subdivision. I didn't want to get into 4 because it can be considered complicated unless you really want to do a deep dive. I'm perfectly happy to do the deep dive. I thought, gee, let's do the easy stuff. Let's get these 3 lots done. And then later, and reserve this. And someday later on.
And I think that's what we figured out, is that we can't create Lot 4 without resolving this.
Yeah, it's not so much a question of, talk about nebulous, but it is super confusing whether this retained land is a part of a subdivision for this reason or that reason and how we're allowed to look at it. The law is very unclear there. But what I do know for certain is we can't create new lots that don't meet our standards. So even if you strip away all the subdivision stuff, at its core, this proposal does create a lot that we need to show meets the frontage requirement, which means it has to have frontage on a right of way that it has access to.
And that can be a paper road.
Yeah, absolutely.
And if a paper road isn't used within 20 years, I believe it's null and void.
And it goes 25 feet to each of the abutters, Maine state law. That is Maine state law. It cannot just get absorbed by one resetting lots.
So can we?
Maine law is 25 feet.
What we can do is request the applicant to supply material demonstrating right of way.
Right.
Right.
Okay. I agree.
Before we get too far off of the road discussion, I think the board, who has the ear of an attorney right now, ought to ask if in fact the Jesse Rollerson plan that was submitted and approved by the board, it got 3 signatures from the Board of Selectmen that was acting as the planning board. If the Jesse Rollerson plan did in fact move the proposed road or if in fact all it did was to change the location of the right of way from along the route of the proposed road, which happens to be along Kara's lot line and 50 feet to the northwest along Mr. Losey's lot lines. And the right of way got moved, and that's what people are using, they were using then and they're using now. But the road itself, the proposed road, did not get moved. Because the Losey plan was not the Losey plan, the Jesse Rollerson plan, as the selectmen said in their vote to approve the change, was only a change of the right of way.
Well, I will demonstrate to you what the planning board did, and I think that'll resolve it.
It did
Well,
not.
and for my part, if the board could make sure I have any, documents that are relevant to whatever, Mr. Losey gives you, if he doesn't give them to you, that would be very helpful.
Here's that document.
We'll get that.
I do need to jump to my other meeting, but
I've been trying to get you let go.
if you're, you know what meeting I'm going to, Mr. Losey. So, I will just assume that this is coming to one of the next two meetings. I'll let the board resolve that and just let me know as soon as you know when that is, so I can get it on my calendar.
Thank you, this was a
Thank you for your
Thank you
time.
very much.
Thank you. I'm so sorry for the delay.
Okay. Where does that leave us? That leaves us tabling.
Right, and so the question is, it sounds like, Mr. Losey, if you can provide us the right of way information for lot 4 to, Marshall Cove Road, whatever.
Or
documentation.
alternatively, just right of way plans for any lots. So I think it's up to you whether or not you want to decide to subsume lot 4 into lot 3, which has the right of way access, or to demonstrate right of way access for lot 4.
This has 200 feet of proposed right of way for a road there now.
Okay,
There's something different.
no, that's what we need for frontage,
Is that,
yeah.
okay.
And we need proof of access to lot 4 from whatever part of Trim Lane you own.
When you say proof, I'm not trying to be cute here, but the only place that can make a determination is the Superior Court. I can offer you what Attorney Collins referred to as title right of interest. The reason she uses that term is that she's representing the city of Belfast. I'm representing a group called Upstream Watch with regard to the salmon farm up in Belfast. And the issue, which has gone all the way to the state Supreme Court, was the value of the indication of title right and interest supplied by Nordic Aquafarms, and what the standard was for title right and interest. We have litigated that all the way to the state Supreme Court. I don't think you want that here. But what I can do is I can present to you evidence of title right and interest clearly sufficient by the standard that the court used to allow that fish farm.
What you get us what you think so we can present it to her.
Sure.
We're gonna have to, another town meeting with the new
I think that,
butters and all that too.
yes. So we got that. A letter. I don't have the green book in front of me with all the people that got messages. I don't know that there are not in there.
You want me to get it right?
The new ones around a lot more too.
Yeah, I'm just
On this order of title, right, and interest, I would like to see the deeds for the paper road. I'd like to see the deeds. This survey does not acknowledge
That's a personal
deeds.
property item. She
This
has to go to her
survey
lawyer and
acknowledge,
go get it.
excuse me,
I'm trying to
I'm
listen.
speaking. this survey in paragraph 1 acknowledges that there are potentially many errors, that it's surveyed for the purpose of the client. But I have not yet found, after much digging, that there is a deed to the proposed road, the uphill 700 feet of Trim Lane. And from all of my work with a surveyor and discussion, Maine state law acknowledges in this situation, you must alert every member of the subdivision, which is Sunset Acre subdivision, and that this needs to be brought up to the entire subdivision as a discussion, as a proposal. If somebody does move in to claim it, all members of Sunset Acre subdivision must be alerted. And we have never done this. We have not legally transferred ownership. I agree that there was a show of the move of the right of way, but the ownership of all of these lands within Sunset Acre subdivision were not owned by the people who are saying they own them. They're right of ways. So we still are building this huge riddle of errors about ownership and right of way. And we need to sort it out for all of our going forward in peace in our neighborhood. It has been 40 years of a mess, and it's still a mess. So we're just creating another mess on top of a mess. So I'd like to see that deed is my request.
I think, you have to go back to 1966.
I have done.
1967.
I have
And
to,
if you look through the deeds, they will reference the right of way to, Marshall Cove Road. So you just have to dig through each deed and you will find that for this subdivision, that the deeds are showing that, with the exception of lot 4, which is much more difficult.
this isn't my question.
Yes, it is.
No.
We're just focused on this Trim Lane Farm subdivision.
But your
We
question
definitively
back to
discovered,
66.
I think what we're concerned about is right of way access into lot 4. And that's it. In terms of like the boundary related to the paper road, that would be a personal dispute. Like that's a survey.
Well,
She
we've
has to
been
get her
talking
own
about,
lawyer.
Yes.
And fight
we've
that
been
with.
talking about
yeah.
deeds. I have never seen that deed.
That's
Why?
immaterial to this matter.
Right.
Why is that? Because we
Because we're
started
only
this whole
concerned
thing
with
out
the
about
structure of these
deeds.
lots. We're not concerned about boundaries. Boundaries are determined by deeds and by surveyors, not by the planning board.
Well, in 1966, Marshall Cove Road was the Merritt
Sounds like something
driveway.
to take up with a
Camp
legal
Road
counsel.
Is what you're calling Marshall Cove. It wasn't Marshall Cove Road in
It's
1966.
immaterial to this discussion.
It's called
So,
Marshall Cove
The
right now.
paper road that we're looking at this new map, one of many issues. This has lots of problems.
It's still
I
property.
think,
What's fine?
It's a subdivision question, it's a state of Maine issue, and it's a planning board issue that they continue to
I'm sorry,
go forward.
this is a boundary dispute.
have to have a.
Okay, no,
But not till we get all
I
the
just don't
information.
does it,
Tiny thing.
tiny thing.
I'm not sure that Mr. Losi has on his list of things to do the letter to the abutter. I just want to clarify that. The letter, the revised letter to the abutters that about the change of the subdivision.
That's what I was just looking at, yeah.
Okay,
And I think that would depend on whether, well, no. If there's a chance he combines lots. that would-
oh, then it would be a moot point, yeah.
Well, I think
Or-
a letter to reflect the updated plan.
Yeah,
All right, right.
so have to know what that plan is.
Right.
Will you waive the letter? Do you want me to send you a letter?
I wait. I'm also not voting in this matter.
All right. Before we get into the finishing off of things here, where are we at? We gotta make a motion on this application.
I move we table application MD 0124 for additional information from the applicant.
And that would include the a butter thing.
Well, not yet.
Oh, no,
No, that goes with
both.
the town meeting.
yeah. That would include the butter.
So we
And
do want him to do that right away.
we want to do that, yes, as quickly as he can. I mean,
Would he have to do it again if he decides to
he
combine?
can make a decision what he's gonna do.
Yeah, that's up to him.
Yeah,
Well, and we need a letter that can be sent on to Attorney Collins.
Yeah. With regard to a letter to the abutters, traditionally in such letters, it say, this is to give you notice of, this is what I'm doing, and here's a smaller version of it. And there'd be a public hearing on a particular date and time. What do I tell them?
did it say a particular date and time on these?
No, I think that's because we usually ask people to do the notice of the subdivision, and then later on, we have a public
So you
hearing.
just want a notice of the subdivision
Mhm.
without, okay,
Yeah.
I'll do
I
that.
think that's.
We assume that the abutters
All right.
will follow, if they have an interest in it, they will follow and show up at a public hearing if we.
Apparently they do.
This public hearing was requested.
Yeah.
Yes, it was. With regard to what Kara was talking about, all members of a subdivision, do you have that someplace where I can look at it and see where it says that's required, that,
I'll find it for you. If you,
well, I was kinda hoping you had it in your hand.
well, there's very good guidance in Maine state subdivision law. It's very clear, laid out like this.
Because that would mean people, whoever was involved in the Sunset Acre, which means even across
Usually it's just
Marshall
the
Cove, I
the
understand.
people around
Yep.
the,
And the original 3 to 4
that are
settlers.
the abutters, not the whole island.
No.
But it's more than the abutters. We all share rights and right of ways on the roads as
But
they
that
are.
includes people on the opposite side of.
If you can submit that information to the planning board, we'll review it.
Focused on the subdivision. Mhm. The current subdivision.
I'm sorry, now I'm confused.
I-
Are you talking about, do you want me to send a notice out to the people up on the top of Marshall Cove Road, up by the main
They
road?
have rights.
Or
to
just the
roads.
people that bought the property in question?
Yeah.
Just the ones that are abut the property.
Thank you, sir.
I will send you that Maine statute. We all have communal use and right of ways of the roads as owners of the subdivision. That's what's being continuously
Well,
overlooked.
as far as I
If
know.
the subdivision is being changed, everybody within that subdivision, the original lots, the owners of the original lot should be noticed.
Can you show it to me in here? Because all I require that I know of is abutters.
Right.
So we'll have to
It's
leave
broader than that.
Islesboro with
I'm sorry?
Maine, but I think Islesboro should follow Maine subdivision law, which became much stricter than maybe our ordinances. We might not be up to date with Maine law.
Time
Um,
to close.
But yes.
Did I get seconded?
You're seconded with additional items.
Did the motion get complete?
What did I?
No.
No.
I need to add letters to abutters to it? What did I say so far?
All you said was, additional information, and then there was a discussion about
What is it?
Related to the right of way.
But we need
Lot four.
clarification
what
on
that
what,
additional information
what
is.
is that?
So
additional-
letter, to them, we can then present to our attorney, the town attorney regarding, lot 4 right of way issues.
And letters to abutters.
Yeah. With a new, figure associated with it.
Figure?
Of the plan, a new copy of the plan.
Yeah, the new updated.
Is this the plan we are now going by?
As far as I know, this is the latest and greatest.
Okay, and do we highlight where it takes away rights from those of us who already live there? What? I don't understand your response. We are
And that's
losing
your motion?
rights,
That's my motion.
property right away.
But-
What does this mean, Jennifer?
I
This is like.
Seconded by Jen.
All right, discussion? All in favor, say aye.
Aye.
Any opposed, say nay. All right,
I have filed with the appeals already about due process, so
Sure.
that'll be interesting.
That's your right.
Mhm. It is.
okay.
There are some rights that.
Continuing on, we are finished with is currently tabled ND 01-24. Once again,
On the correspondence.
correspondence, I have 0. Committee report, and I have no additional business. So we need a motion to adjourn.
I move we adjourn.
Second.
Discussion.
Prejudice.
All in favor, say aye.
Aye.
Any opposed, say nay.
Hey, that's one way to see her.
We do it every night,
All right.
but this is our spot.
No, boy.
Glad we could help keep the lines of communication open.
Yeah, really, it's amazing really that you can participate in a meeting like this, it's really amazing.
That's what democracy's all about, right?
Well, we hope so.
Thank you, because I was. Right, I didn't know, but you know.
Yeah.